Hey there, thanks again for tuning in today to You're Free to Go. You're about to hear about some of our crazy ass cases that Mark and I always love sharing with you. Mark's going to be here in studio next week, but right now he's still out in LA. So, hey, Mark, how's it going out there?
Excellent. Weather's perfect. Our temperature is very accommodating. I understand it's pretty warm in South Florida right now.
Yes, it is. It is warm. And, it's like a broken record when I ask how LA is because it's perfect. It's always perfect out there.
Well, nothing is perfect. We pay heavily for the weather. I just
Yeah.
filled up a tank of gas, premium, this morning, and it broke $7.
Wow.
$7.01.
Oh, man. Oh, man.
Imagine.
Yeah, time to get an electric car. Yeah.
Ugh.
Copy. You got to get like me,
Yeah, but
Mark.
then when you see my electric bill, you'll know why.
Right.
Gas cars.
That's a whole nother issue, I guess, out there. Yeah.
Yeah.
Well, a couple episodes back, we were talking about opening with questions that our viewers, our listeners are sending in to us, which is really exciting because they're really engaging in the show. And one of the things that came up, which I thought, well, geez, we should really talk about this. It's the first thing that comes up when someone gets arrested. It's the most important part of a case the moment someone gets arrested, and that's a bond. How someone bonds out when they're arrested. And obviously there's some charges like murder that you cannot bond out on, or you can get a bond hearing, but constitutionally you can be held in jail for a charge like murder. But since it's the first thing that happens in the process of someone being arrested, I guess we haven't mentioned it yet, so we might as well just kind of open up today's episode and address that. The issue of bond and a bondsman and how that works. Because if any of our listeners or their loved ones or friends they find themselves in a situation of being arrested, now they'll at least know how to focus on the initial crisis, which is to try to get this person released from jail as quickly as possible. So I'll just start by saying, the statutes in the states of the criminal rules of procedure and so forth, they establish in the state system, and Mark, I'll let you address the federal system, but for the state system, when someone gets arrested, the bondsman charged 10%. So if the bond is set by a judge at $1,000, the bondsman charges you $100. That's 10% of the thousand. Now, the bondsman, every bondsman is created equal. In other words, there's no competitive advantage from one bondsman to another, because think about it. If one bondsman said, "Oh, I'll do it for 8%," then the next bondsman is going to say, "I'll do it for 6%," and the next one's going to do 4%. So they all stick to it. The statute says 10%. So they just stick to 10%. It maintains the industry integrity for them so they don't undercut each other. So basically, the 10% in this example of 1,000 is what the bondsman gets. It's their VIG. I call it their VIG. It's their fee for doing their job. And their job is to then take a piece of paper, which is a insurance bond paperwork, and give it to the clerk of court. And that bond and paperwork basically says, if this person flees, if they don't show up for court, we are on the hook for the $1,000. So the bondsman will pay the 1,000 to the court. At first, they're just giving them a piece of paper, but they are agreeing with this piece of paper that if the person doesn't show up in court, then the bondsman owes the 1,000 to the clerk of court. So what does the bondsman do? Well, they get collateral. So they get a $1,000 bond. They get $100 up front. That's their profit. That's how they make a living. And then they get collateral for the $900 difference. Sometimes it's a watch. Sometimes it's, it could be a much larger amount of money. It could be a $200,000 bond and so forth. It could be a title to a home. It could be all sorts of things, whatever. It could be a jet ski. I've seen that before. And that collateral is there so that if you flee, then the bondsman isn't out the money per se. So why is there a bond? The bond is so that someone shows up in court. They believe the courts feel like if you have this financial stake in your case that you won't take off, you won't flee, you will show up in court. And at the end of the hearing, when the case is over, the paperwork, this paper bond that the bondsman posted, gets shredded. Basically, it gets torn up, returned to the bondsman, and it's over, you do not get your 10% back because, as I said, that's their vig, that's their profit, and but the bondsman is now off of the hook for the $1,000 in this example, and they turn your collateral back over to you. The key for the bondsman is to make sure you don't flee. So the bondsman's always going to make sure you show up in court. That's their job. And if you do flee, they have, in most states, they have 6 months to find you and produce you in court. So what I have seen happen is a bondsman starts to get nervous. A case doesn't get over in the first month. The average misdemeanor is 6 to 12 months. Felonies can be 12 months to several years. So they're monitoring this case closely because there's lots of court hearings. And if they get nervous, maybe they think you're going to flee, they'll often go back to court and say, we're not willing to hold this bond for this person anymore, and we're going to surrender them. So they'll literally pick you up, bring you to the court, and then you have to figure out a whole nother way to get out. It doesn't happen often. I mean, I think I've only seen it maybe 3 times in my 34-year career, but they do have the right to surrender the bond and tell the court we're no longer willing to take the risk on this individual. But if the person flees, they have 6 months to find them and turn them in. If they don't find them, then they owe the money. In this case, the hypothetical I gave was $1,000 they would have to pay. But the collateral is key. I know an example of a bondsman. He was the biggest bondsman in Palm Beach County. When I was a prosecutor, he did all the bonds. And he had a defendant, sexual battery case, and he put the bond very quickly. He was really good friends with the criminal defense lawyer, this bondsman. Criminal defense lawyer said, hey, it's a really big case. Get this guy out quickly. I don't want to lose this case. It's a big fee for me and my family and so forth. They had been working together. Actually, this lawyer sent this bondsman a lot of business. That bondsman sent the lawyer a lot of business. There were actually kickbacks going back and forth between the two of them, which was against the rules and against the law and so forth. So that was a whole nother issue that got the lawyer in trouble once, with a criminal investigation. But anyway, this bondsman quickly wrote the bond and got the guy out. It was a $250,000 bond, and before having the family come in and sign all the collateral. Now this defendant disappeared. He was nowhere to be found, and this bondsman had 6 months. He hired other private investigators. He did everything he could to find this guy who was out on his bond, $250,000 for sexual battery, and he never ever found him. And literally, this bondsman, who was the biggest in town, was put out of business. He had 2 reasons. One, he had to come up with the $250,000. After 6 months when he couldn't find them and produce them. But number 2, bondsmen they're just a sales rep. They're an intermediary between the defendant, and the clerk of court, and the insurance company, the underwriter, so to speak, the big company who puts up these bonds. They use the bondsman to kind of be their representative. So what happened was, when this bondsman had someone flee on him and he lost a $250,000 bond because he hadn't gotten collateral because he'd rushed it for this lawyer friend of his, no insurance company, no underwriter would ever write with this guy again. So not only did he come out of pocket $250,000, but he couldn't get any companies to approve his bonds. So he was literally out of his livelihood and had to go create a whole new career, which was kind of, a shock to his system. He was making a ton of money, and he's never fully rebounded on that. One other little fun fact, by the way, is, and I can say this as a fact because I've represented uber wealthy clients over the years. We're talking multi-billionaires and so forth. A fun fact for you to know is that even in a case where it's a low bond, like $1,000 or $5,000, and I have a uber wealthy client who walks around with a couple thousand in their pocket every day, they still use a bondsman. And here's why. And it sounds silly, but you'll have someone who says, hey, the bond's $1,000. They say, I've got $7,000 in my pocket right now. Just put it up. Well, what happens is these bondsmen are in the court every day. They go to the jail every day. They're constantly bonding people out. So they know all the players inside the jail, all the people that are, when I say players, I'm not talking about the defendants or the inmates. I'm talking about the workers there, the people in the department, the bond department, the release of from jail department. And usually these bondsmen are former cops that actually worked in that job. So what that bondsman does is they'll go and say, hey, this is one of my clients, make me look good, get him out here as quickly as possible. And they work with them because they know them, they see them every single day. But if you were to put up the money, let's say my famous client, my rich client could be a wealthy doctor that's not famous. They say, here's the $1,000. That cash bond, instead of a surety bond, the insurance bond, goes to the bottom of the pile. The people working in that department at the jail put the cash at the bottom of the pile, and they do professional courtesies for the bondsmen who are coming through saying, hey, this is one of my guys, make me look good, get him out here quickly. So that's a kind of a fun fact that I've had these billionaires who literally could post the bond in their pocket, but yet we still use a bondsman for them. So that's kind of how the bond works. And again, at the end of the case, it all gets released. And you don't owe the bondsman any money, but you don't get your 10% back. I know federal is different. Mark, I'll let you kind of go explain how the federal bond works on that.
Okay, well, first of all, let me just comment a little bit about what you were saying about state bonds, because early in my career in Florida, in the 80s and even the early 90s, I was doing a lot of state court work. What I found was a lot of the bondsmen, there was a lot of competition, especially in drug cases, amongst bondsmen to get you work. And a lot of times they flew, somewhat naked in that they did not fully collateralize themselves.
Yeah.
And that was attractive to the defendants because they didn't have to put up all the money or all the collateral. And of course, those bondsmen, like you mentioned in your example, quickly learned that that was a very foolish way of doing business because not only are you stuck with the court, but you're also in a situation where you could lose your license, your ability to have an underwriter. I had one bondsman, I remember, who was flying kind of naked, as they called it, and he only had a little bit of collateral on a $500,000 bond. The defendant fled. It was beyond 6 months, but they managed to find the defendant in Hilo, Hawaii. And they grabbed him. It was sort of like out of the movie, what was that, Midnight Run with Robert De Niro and Charles Grodin?
Yeah.
And they got him back. They physically grabbed him and they took him back on a plane and they had him handcuffed on the plane. And they they produced him in court and the prosecutor agreed, and we got the court to actually undo the forfeiture of the bond, which was a rarity. It almost never happens. But let's talk about federal, because the federal system is quite different. First of all, in the federal system, you use bondsmen much less. And that's what we call a surety bond, a corporate surety bond. In the federal system, a lot of times your client can get what's called a personal surety bond or a signature bond. It's called different things in different jurisdictions, but it exists everywhere. And that is the court feels comfortable with your client's promise to show up. The charges may not be that serious. He's not a flight risk. Um, he's been a member of the community for a long time, or he's cooperating with the government, in which case the government has no problem recommending that kind of bond. And you simply sign a bond form that says, if I run, if I don't show up, I owe the government X amount of dollars, whatever the bond is. If let's say it's 250,000, you sign a pledge that you owe 250,000. Usually those personal surety bonds are backed up by other family members who sign those bonds. So it's more than one surety.
Yeah, I found those, the one you're talking about at this moment, to be easier than dealing with the state very often, because it's basically a promise to show up, and others will sign off
Very
on it
simple.
as
You
well.
sign it right
Yeah.
there in court
Yep.
when you go to the bond hearing. And if you have your wife, you have a family member, sign it. Of course, by then the court has already learned what your financial situation is, assumingly you've answered truthfully when you've gone through the pretrial screening, or in this case, uh, it's a pretrial services They interview you before your bond hearing. They double check. They call the wife, they call family members. And if the court feels comfortable that there's sufficient assets there to back up the personal pledge, then they grant you that, you sign it, and you're out within a short period of time. In the federal system, it's much less frequent that bondsmen have any kind of pull within the marshal
That's
service.
right. Yeah.
So using a bondsman is not necessarily to your advantage. And there is one other disadvantage to using a bondsman in the federal system, and that is that instead of it being a 10% fee, in the federal system, it's a 15% fee. So if your bond is $100,000, you're now paid the bondsman
Right.
15,000, and that's gone
Yeah.
forever. Even if you show up and eventually the bond is what they call exonerated at the end of the case, because you've complied with all the court conditions. Either you're found not guilty, you're free to go, or you've been sentenced and you show up where you're supposed to be at the sentence, then the bond's exonerated.
Yeah.
In addition to the personal surety bond, the another alternative is just simply a cash bond. You put up $100,000 with the clerk of the court. The advantage of that is if you have the money, when the case is over, you get the full $100,000 back. So you haven't paid a fee to anybody.
I'm
Uh,
always a little cautious about that, Mark, because I've seen it when I was a prosecutor. Actually, I used to do this trick all the time. I would, at the end of the case, but when we're trying to resolve it, I would see that there was a bond in place, a cash bond. I mean, as you just described it, meaning literally cash was put up by the defendant and or their family, and I would see that there was $20,000 in investigative costs and so forth, the court costs, fines and so forth. And I would put in my plea offer that we're going to keep that money and apply it to costs in the case. And so the defendants were expecting to get it back, and then they didn't. But it was
well, that I see that certainly in the state system. In the federal system, and I've been doing this for forever, since the Jurassic period. Um, I've never seen an assessment of court costs
right. But
or
fine. But there could be
investigative costs.
restitution and so
Well,
forth. Yeah.
restitution, and then there are
Yeah.
situations where the government may say, look, you're going to get that money back, but we want to apply it to restitution.
Yeah.
I mean, it's a mixed bag because at the end of the day, you're going to owe the money anyway.
Correct.
And if in fact, as part of your pitch to the judge at the time of sentencing, judge, I have $100,000 sitting in the thing, we gladly apply that to restitution. It makes you look better
Yeah.
to the court
It works.
when the judge is ultimately sentencing
It
you.
works great unless you're surrendering money that actually a friend lent you for so
Well,
you to get.
then you got a problem,
Yeah,
yeah.
yeah,
But
your friend
the,
has
the
the
other
problem.
the other issue is that when you put up money in the federal system, they use a term. It's called a nebia hearing.
Sure.
And
Yeah.
nebia hearing came about. The term came about as a result of a case back, I believe it was in New York, involving a mob case. And back when I was prosecuting those types of cases, the issue was you wanted to make sure that the money that's being used for the bond is clean money, not the proceeds of criminal activity.
Ill-gotten
So
gains, as they say.
right, right.
Yeah.
So the prosecutor may require what they call a nebia hearing. In other jurisdictions, they may call it something different, but typically called nebia.
Yeah.
And they just want to make sure the funds aren't tainted, in which case you've got to come in and demonstrate to the court. First, you demonstrate to the prosecutor, and usually they'll stipulate where the money came from, how it's not involved at all with the criminal activity under charges, and then you can use it. There's another form of bond which has become more and more prevalent, and I've used it a lot, and that's basically a property pledge. And that's basically, let's say the bond is $1 million, and what they do is they turn around and they ask you to pledge property. Um, you have to establish the value of the property, usually by some form of appraisal or tax records at a minimum, which are always lower than the appraisal, and then show that it's free of any. So you have to have a title search, show that it's free of any kind of liens or whatever those liens are, there's still enough equity to satisfy the pledge of the property towards the bond amount. And then you've got to record it with the court.
Right.
Now, those are complicated processes and it may take time. And I've had cases where instead of waiting the week or two, they'll let you out conditionally upon maybe a personal surety pledge with the understanding by such and such date, the property bond has to be perfected.
Right. And if you
So
don't,
those are the main types of
yeah,
bonds
and
in federal
and
court.
if you don't perfect it, they put you back in the jail. So which,
Yeah, well, sometimes you
yeah,
get more time because it's just been a
right,
hiccup in the
right,
technical process.
right, of course.
You can
So
show good faith.
So I do think I want to clarify, and just one little point, two little points, and then we'll jump into some crazy ass cases. One is that there's there to get released from jail. There's a bond, which is the money aspect. So and there's a second part, which is like terms and conditions of release. So the judge at the bond hearing and so forth is looking at, are you a flight risk? And number one, that's where the money comes in. And number two, are you a danger to yourself or to others? So there could be other conditions. Sometimes one of those conditions applies to the money side, the flight risk side, which is like surrender your passport. But let's say you have a drinking problem, you got DUI, serious bodily injury, car accident or something, or you're in securities fraud in a federal white collar case. They may say, okay, you can no longer drive because you had a DUI accident, or you can no longer work in your industry until this is resolved and so forth. So those are conditions of release to make sure you're not a danger to yourself or to others. And the flight risk part is the passport. But the one thing real quick, Mark, is the other point I want to make is how a judge comes up with the dollar amount. In state court, they create a menu for about 75% of the crimes. Shoplifting, you get released on your own recognizance. You don't have first time offense under $300. You don't have to put up any money. They book you, they release you. It's called OR, your own recognizance. Sometimes, let's say it's your third shoplifting, there's a schedule, it's a menu, say third shoplifting, $250, or possession of cocaine, trafficking cocaine, so it's 20,000. So it's a menu, so when you get booked and you go through the whole process with the staff, they say, okay, this is how much it is. And then there's a percentage of these crimes that don't have it. They require you to go before the judge. Typically, if there's a victim involved, you have to go before the judge who will come up with the dollar amount and any terms and conditions of release. And the reason for that is they may want to add a no contact order with that victim. And you have to have a judge issue that order. So that's why they might have you stay and go before the judge. But it's always interesting to me where they come up with the dollar amount. I've always found that when it comes to drug trafficking, the courts assume that you must be super loaded, rich, because drug traffickers, drug dealers have lots of money. And that's not always the case. They could be a little petty drug dealer in town doing some little, marijuana deals here and there for $30, $60, $100, and to their entire life savings, they have $1,000 to their name, and they get hit with a trafficking, and they get a $20,000, $30,000, $50,000 bond, and it's tantamount to no bond, meaning you might as well say it's $10 billion. They ain't getting out of jail because there's no way they can afford it. But it's always interesting to me how a judge comes up with the dollar amount in these cases relative to if you have someone who, let's say they stole a car, and to their life savings, they have $1,000 versus someone who's got $1.5 million in the bank. The person with the $1.5 million, to make it so they're not a flight risk, their bond could be $50,000. But the person that's got $1,000 in the bank, their bond might be $100. So it's an interesting part of the process. And obviously, we as lawyers get in there and argue for the lowest possible bond. The prosecutor typically argues for the highest possible bond. And then it winds up wherever the judge hits the gavel is the final number. So, any other point on this bond issue, Mark? Before we
Well, just one final thing that, in federal system, the bonds are determined initially by the federal magistrate. They're like a junior judge. They're not appointed or nominated by the president and confirmed by Congress. Um, and they are, usually very well intentioned and very well experienced um, magistrates who make these judgments every single day
yeah,
on bonds. There is no schedule. Different magistrates have different concepts of what's a sufficient amount. A lot of times it's a matter of hearing from the government first. And frankly, in I would say in the majority of cases, the government's asking for pretrial detention, claiming that the defendant is either a flight risk or a danger to the community. And danger to the community doesn't mean that they're going to go out and shoot up, an establishment. It means that they're going to engage in further criminal activity,
Correct. Yeah.
and even white collar criminal activity. So the magistrates
Yeah.
make those determinations,
Yeah.
and frankly, it's hit and miss. You
Yeah.
never know what they're going to do.
Yeah, and in case any judges are listening today, Mark, of course, if they're our client, they're definitely not going out there and committing more crimes or doing anything outside, drawing outside the lines,
Right.
because they follow our advice, they listen
Well,
to us.
we want to make sure we don't lose credibility with the
That's
court,
right.
just
Yeah.
like the judge does want to let somebody out who's going to run, because then and you don't want your client to run because it kills for the next guy. But the other thing that you need to realize is that in when the setting conditions of a bond in federal court, they always automatically limit you to travel within that federal district.
True.
The federal district may be a couple of counties, depending on where you are. For example, here in California, Central District of California is basically the LA County
Right.
area. Um, and what you do sometimes if your client has to travel or they have to travel to see lawyers out of state or they have medical reasons or family reasons, you ask for extended travel. I'll often ask the court for travel within the continental United
Wow.
States. Rare that they're going to let you travel outside the US.
Right, I agree. And I think one of the things you just kind of alluded to, hopefully the nuance our clients picked up on, was that you said you kind of ruin it for the next guy. If a judge gives a bond to somebody and it's like $1,000, it's the government wanted higher, but we only wanted, the government wanted 50,000. We asked for 1,000. Judge agrees, and then that guy flees. All the defendants that come before that judge in the future are going to get really, it's going to backfire on those future defendants because that judge is thinking in the back of his mind, I had a similar case a couple of weeks ago. I gave him 1,000 and he fled. So future defendants are going to suffer because the judge cut a lawyer a break for their client and then the client took advantage of it. So we're going to take a break for a minute because we dress so sharp on this show and we got to recognize our sponsor, Milburn Men's Clothing. But when we come back from the break, Mark, I want you to share one of your crazy ass cases with our audience, and then I have one for us too. So hold on, you guys, don't leave. We've got some good cases for you coming up. Here's a quick break. Your Free to Go is sponsored by Milburn Men's Clothing, where top athletes shop for sharp, tailored style. And whether Mark and I are in the studio or the courtroom, Milburn dresses us for success. Mention YFTG and get 10% off at Milburn Men's Clothing, which has been providing the finest in men's clothing and suits since 1946. Call 651-645-2922 or visit www.milburn.com. All right, Mark, we're back from our break and from our Milburn Men's Clothing, who we're so appreciative for dressing us so to be the sharpest lawyers in the country, sharpest looking and sharpest in the courtroom as well. So, Mark, why don't you share one of your crazy ass cases today, and then I'll jump into one as well.
All right. Well, I alluded in a prior episode to having a matter, and I think it related. We were talking about scams and dating sites and um, romance scams. I was mentioning, and I mentioned that I had a case that was a little blue in nature, and I'm going to dare to tell about it here because this is not network TV.
Yeah.
And certainly not showing pictures, but I think the description will be somewhat salacious. Anyway, I had a client who was an American citizen, but he was working in a foreign bank in the Far East. And he was an executive at that bank, not at the top, but well placed. And he had a relationship with another woman at that bank who was equally placed. So there was no issue about, um, you know, taking advantage of her because she was a subordinate. There was no allegation of sexual harassment at the time. And I don't even think the bank knew about it, frankly. But even if they did, they may not have frowned upon it. I don't know what the bank's attitude was. In any event, they had this wild relationship, wild in the sense of sexually wild relationship. They engaged in just about every kind of fetish you could imagine. And one of the things they did was they photographed everything.
Oh yeah.
And of course, they never disseminated these photographs. Um, they kept them, I guess, in their computers or wherever they stored them. And then they had a big breakup. They were sharing an apartment and they had a giant fight, and she kicked him out, but he still had the key. She went away on some kind of vacation and he went to the apartment. The apartment was technically in his name under the lease, so he was legally entitled to enter, even though she threw him out. And he went into the apartment. Now, one of the things he did at the bank initially before he became an executive was he was in their computer programming division, and he was a whiz at computer programming. Well, he broke into her computer. That is, somehow he found her password or he bypassed it. I don't know the details. And he found some of the photographs. And one particular photograph he found was of her performing oral sex on him. And it was a very vivid picture.
Hmm.
She was about to have a high school reunion, and she was in charge of sending out all of the invitations to her hundreds of classmates
Oh,
who were located all over the world.
I have a feeling I know where this is going.
Oh, yeah. And so he was so angry at her. He was such an asshole, actually, for doing this. He was so angry at her, he decided somehow he managed to attach, without her seeing it. I don't know how he did this. Um, Without her seeing that there was an attachment to every invitation she sent out was a photograph of her giving him a blowjob.
Oh my God.
So imagine how mortified this woman was when she found out that hundreds of invitations went out around the world for this reunion, and it had that photograph.
Jeez.
Uh, she, according to her lawyer who called me, because he wanted to have him prosecuted,
Of
my client
course.
prosecuted, um, she was suicidal,
Oh, I can imagine.
understandably so.
Hmm.
Well, it got very interesting because the lawyer, who was a former assistant U.S. attorney in the United States, tried desperately to get the U.S. to charge him. Problem was there was no U.S. jurisdiction other than the fact that he was a U.S. citizen. None of the people who she sent out the invitation to were located in the US.
Oh, there's a legal.
And
Yeah.
the problem was in the jurisdiction that the bank existed, there was no specific statute that covered it. Now, in some of the other jurisdictions, but we're talking about probably 10, 15 countries around the world, there may have been, but it became almost an impossible task to try to get any of these other countries interested in prosecuting him. So he went free from any kind of criminal charges. They initiated a civil lawsuit in the United States. The problem was he was no longer a resident of any state in the United States, so they couldn't get jurisdiction for purposes of personal
Mhm.
jurisdiction to sue him. So that got
Right.
dismissed
Like the
when they
perfect
tried to
crime.
sue him.
It's the perfect.
It was literally the perfect
Yeah.
crime, but he'll probably be damned to hell. I
Sure.
mean,
He'll never be
given
able to
what
get a
this guy
date.
did.
He'll never get a
Oh
date.
my
That's for
God, could
sure.
you imagine?
Yeah.
So, I mean, I'd have to say of the clients that I've had over the years, this was, other than the murderers, the mafia hitmen, the Colombian hitmen who hit women, the drug dealers, the Ponzi schemers.
We,
This was probably one of the
mm,
lowest things
yeah,
anybody ever did
we've
to
had
somebody else.
we've just had such colorful characters in our offices over the years. You know, human beings are we are flawed. You know, we they make mistakes,
Yeah.
and a lot of times I see these people. You know, as low as that was, I see these clients who do. Jeff Epstein's a great example. There were sides of him that were really brilliant and productive and of great value, but yet they have a dark side that's abhorrent, that's criminal, that's abusive and victimizes others and extorts and so forth. And it's really hard. So it goes back to what we've talked about sometimes. The psychology behind it is always fascinating, and that may be one of the things that drew me to criminal defense. Is a lot of these clients. There's career criminals, of course. If you sit in a courtroom, you'll hear about someone who just they commit a new crime every couple months, they get rearrested. But the majority of defendants have never been in trouble before, and they have certain demons that get them in trouble. And
Well, you know the expression, we criminal lawyers see the worst people at their best, and divorce lawyers see the best people at their worst.
exactly, yeah, yeah. So it's such an interesting thing that people do this and destroy others, and narcissism
Yeah.
and so forth. So I have a,
Well,
I
you
have
must have a
yeah,
crazy case to tell
well,
us.
yeah, it's not one that I was representing someone who was arrested. It's just came up, when people call us, they hear you're a criminal lawyer and they'll call for all different things. They hear you're a lawyer. So, I'll get a call for a divorce. I said, no, that's not the type of lawyer I am. But, okay, so this was kind of an unusual situation where I got a call. There was a company that called me, a president, a founder of a company, because he had had a holiday dinner party. It was a few years ago now. It was right around, I believe, around the COVID time. They had the holiday party, and one of his employees had stepped out. He had about 60 employees. One of the employees had stepped out of outside the restaurant. It was a private restaurant they rented out for this party to go get some fresh air. And the restaurant was next to a train track. It's a Florida case. The train was one that went. They had two tracks next to each other. One headed northbound, one heading southbound. It turns out that this gentleman wound up getting hit by a train and dying. The police did a investigation within under an hour. They concluded it was a suicide by train, which is not uncommon. Maybe people have heard of that: suicide by train, suicide by cop. That's when I think we talked about that in another episode, where someone who wants to commit suicide, they get involved with a police situation and they intentionally create this scenario where the police show up and they pull the gun out, and then the police wind up shooting them. Suicide by cop. But suicide by train is also sadly very, very common. And so the police quickly concluded, literally in under an hour, that this was a suicide by train. The family of the deceased, he was married, he had children, and his parents were still alive, the siblings were alive. They did not believe at all that this was a suicide. They said there was no way whatsoever he would commit suicide. He loved his children too much. He had a wonderful marriage. He loved his job, which, working for this company and so forth. So they wound up suing the employer. They said the employer served alcohol at this party. So they argued that they overserved him alcohol. And therefore, when he went outside to get some fresh air, he was totally inebriated, impaired, drunk, as they say, as a result of being overserved at this company party, and that they wanted to sue the company for a lot of money. They hired a lawyer and so forth. So the company says to me, we don't believe, we don't know what happened here, but we got to get to the bottom of it. Can you help us? So I said, well, yeah, I have a private investigating, staff in my criminal law firm. Let's get them on it. So the first thing my PI does, people not sure, PI in this case means private investigator. Another term in the legal field for PI is personal injury attorney, like a car accident attorney is a PI attorney, or slip and fall is a PI attorney, personal injury. But PI in this context in law is private investigator. So what they did was they went and they searched right up the tracks, maybe about 1,000 yards away from the restaurant. Up the tracks was a 7-Eleven. So they went to that 7-Eleven, spoke with them, and they secured the video from that 7-Eleven after talking with the person working on duty that night. And they were able to show that the individual, the employee, had actually walked the 1,000 feet or so to that 7-Eleven, bought cigarettes, and the video showed absolutely no signs of impairment. There wasn't any, it actually was video and audio. You could hear that the employee was speaking clearly. The deceased was speaking clearly. He wasn't losing his balance. He was making sense and so forth. And then he was walking back. So what happened on his way back, he was walking back, and that's when he was on his way back to the restaurant when he got hit by the train and killed. My private investigator then used their contacts at the police, police contacts. They had, my private investigator used to be with the police. They used some of their police contacts to get to the hospital and get the lab results from the hospital. And they were able to determine that they did run blood tests, and there was 0 alcohol, 0 drugs found in the deceased's blood. So he was absolutely, unequivocally not impaired under the influence whatsoever by alcohol or drugs. So that was a good sign as well. So what did the guys do next? Well, still needed to understand what happened. Like, why did this guy die? So the PI then the private investigator pursued the train company and got a video of the train. It's like a dash cam in a police car. They have dash cams on trains. They have several video cameras on the trains. Obviously only video, not audio. And what they showed was really, and I've seen the video, and it was pretty disturbing on emotionally, and kind of one of these things that I could never block out. Once you see it, you can never, never forget it. So he's walking south back to the restaurant. These tracks are to the right. Immediately to the left is the northbound lane. This gentleman, this employee, while walking south, there's a train heading north. No big deal, though, because this employee was on the southbound track. So when a train is coming, we probably all know, either from common sense or from being near a train track and maybe with your bicycle waiting for a train to pass, there's a lot of vibration. You can actually feel it, from a half a mile away. You feel the train coming, chugging along, and there's vibration, and there's also some noise, right? There's noise. There's also, at this point, it was a dinner party, so it was nighttime. So there's also a light shining, a headlight, like a car headlight coming. So again, this employee is on the right side on the tracks heading south, and he sees a train in the left lane, the left train tracks heading north. He just keeps walking because he's in no danger whatsoever. He feels the vibration. This is all assumption, but common sense and logical assumption. He hears it. He sees the light coming at him. And at the very, very last second, you see this employee turn his head 180 degrees basically and look behind him. And at that same moment that train heading northbound was approaching him, a train was on the southbound track heading right toward him. He looks at the last second and he sees the train with no time for him to jump out of the way, to jump off the tracks, and the train hits him, and instantly he's killed and dead. Really horrific. Clearly it was an accident. He never intended to commit suicide. He wasn't impaired. He was just guilty of not being smart and walking on the tracks, which, by the way, is a crime. Anyone who walks on tracks, knows anyone on tracks, not only is it putting your life in danger, is it super dangerous, literally could be life-threatening, but it's also against the law in every train track in the country. So the video was revealing. It's often the best evidence. Mark, you just talked about your case where there was a video of someone, giving oral sex, giving oral sex. video is very, it's not always conclusive. It can be misleading, but in this case, we have another video that was that basically solved, the crime here.
So let me ask you this: did he have an insurance policy?
No, he was a lower level employee. Didn't have much money. There was no insurance.
Well, that would have made a big difference,
Well,
though, the result,
mm,
if he had an insurance
yeah,
policy, because many insurance policies are negated or exclude suicide. Could you
yeah,
imagine if
yeah.
there was an insurance policy and all of that work ultimately went towards
Mhm.
proving that it
Well,
wasn't a suicide?
you're right.
Could be worth a lot of money.
Absolutely. And we've seen obviously that happens in life often, and the first thing they look at, you see it on, Dateline episodes, they say, was there an insurance policy and so forth.
Right.
The problem here is the police did a quick under 1 hour they didn't do an investigation. They drew a conclusion very quickly. They should have conducted a thorough investigation, but it was like, to them, low-hanging fruit. Oh, the guy walking on the tracks clearly was committing suicide. But for this employer actually putting out the money to try to help this family. Obviously, they wanted to defend a lawsuit too, but they love this employee. He had been there about 18 years, and they wanted to get to the bottom of it, so they were willing to pay this money. And Mark, it's a good question you asked about life insurance, because there was not life insurance, but the family dropped the lawsuit, and the employer wound up setting up a very substantial fund for the employee's 2 children, a college fund, as well as some additional funds to help them in life going forward. So at the end of the day, even though they lost their father, the spouse lost her husband, the employer really did step up and do right by them. They not only paid to the private investigating and my firm to figure out what happened so the family could have some closure and peace, but also to give them some financial security going forward. So that was a good ending for them, even though the loss of their father and their husband can never be replaced. And the other warning, is, when you have an office party, in this case, this individual did not drink any liquor, but office, when you own a company and you have office parties, you got to be real careful about serving liquor, maybe 1 drink maximum per person or no alcohol at these parties. And of course, employees want to go to a holiday party. They want to drink and have a good time, but that can, in this case, it wasn't the cause of what happened, but we have had cases where there have been, as a result of serving alcohol at holiday parties, where something has gone sideways, very bad, with damages, and employers have been held liable and accountable and so forth. So just a warning to employers out there, think twice before you have a office party, holiday party, etc., where alcohol is being served. So that was an interesting case, not one where I was a criminal defense attorney, but kind of helping this family work through what was a very tragic situation. And
I think this has been a fascinating episode. We told them about bonds. We
yeah,
told them about some of our crazy
yeah.
cases.
Next time, it's just crazy cases, all right? Because
Right.
I have
Okay.
so many
I,
that I can't wait to share.
okay.
All right.
Well,
But
that's great.
we
Well,
gotta remind them to like, follow, subscribe. That's
right.
always really important. And thanks again to our sponsors. And now I guess we'll sign off, Mark. How do you do it every
Yes.
time?
Every time we say, until the next time, ladies and gentlemen,
You're
you're free to
free to
go.
go. Everything expressed and discussed in this episode are the opinions and experiences of attorneys Guy Fronstin and Mark Nurick and their guests. All ethical rules are complied with. Attorney-client privilege and confidential information is not shared or released during these episodes, and names, dates, locations, and other identifying information may be changed to protect confidentiality. Topics are embellished, and none of the statements made constitute legal advice and should not be considered or relied on as such.